Hey, what's up YouTube? Jeff Lauder here, your favorite criminal defense attorney out of Orlando, Florida. Today we're following up on one of those hypothetical cases and bring you up to speed on it. There's a couple other videos on it, but this video should suffice. Just review the facts briefly. So my guy is, hypothetically of course, is driving on the road. He's speeding at late at night, activates his blinker the wrong way and is then pulled over. Officer smells alcohol. Says he observed slurred speech, ends up pulling the guy out of the car, says, "Will you do field sobriety exercises?" And he says, "Well, I don't have to, do I?" And the officer misleads him and says, "Yes, you do have to perform them, or else your license will be suspended." We filed a motion to suppress on that issue, and we won that motion to suppress. And the argument was, you can't mislead someone into performing field sobriety exercise or consenting to a search if it's based upon false information. So we won that aspect of it. There's a whole other factor to this case. You see, it's alleged that my client was under the influence of
marijuana at the time, and he was tested for urine, or his urine was tested
and showed up positive for delta tetrahydrocannabinol,
THC. And so the state is going forward on the grounds of 0.05 breath alcohol level and then marijuana in the system to show that both of those combined together cause his impairment. And he messes up on the field sobriety to exercise a little bit, so it could be confused there. There's a few mistakes he makes. Definitely performs pretty well though, and don't really see any other indicators. So the state's case is kind of wishy-washy with a low blow on marijuana in the system, because they have to prove that marijuana was psychoactive at the time. They got to prove that the person was actively under the influence of that drug at that particular time. And with marijuana staying in your system for periods of weeks, depending on the amount of usage, then that makes it much more difficult for them to prove, but they can still prove it. And in this particular case, the only reason why the officer requested a urinalysis test was because the breath test results were below the legal limit. So he only blew a 0.05 whatever, and the officer said, "Well, you must be impaired on something else." So here's the problem with that. In order for the officer to request urine, he has to have reasonable suspicion of drug use. And that reasonable suspicion can be based upon the degree of impairment being inconsistent with breath test results. That could be a thing. I blow triple zeros, but I can't even stand up. Whoa, I just realized that I got a pen in my pocket and I look like a nerd. Well, I guess I'm an attorney, so that might be okay, but not for this video. In this particular case, there was no evidence of drug use. There was no paraphernalia. There was no odor of marijuana. There was no indicators that were specific to marijuana. So there was no connection to marijuana at all. And that's not a reason for a police officer to request urine. So that urine was held to be inadmissible in court. The request for field sobriety exercises was held to be inadmissible in court. And so now the state of Florida, the case still can go forward because they have the circumstance that the stop was lawful, so they can proceed there. And they can go all the way up to the point where he asked him to perform field sobriety exercises. And then they can show the breath test results. If they can show the jury, or they can show the judge, I guess it has to pass judgment of acquittal first, but if they can show the judge and the jury that there's impairment there, then the jury is going to make the decision on whether he's impaired or not. Now, that's not a lot to go on. It's not at all, and that's crazy for them to go on that case. But that's something that could happen. I mean, that's a possibility. I think it's an unlikely possibility, but it's definitely possible. And a conversation I had to have with my client. I had to talk about that. Hypothetically, I had to talk about that. So, and we battle with that. We struggle with that. What are we going to do if we're going to go forward? They're going to give you a sweetheart offer deal. If I can't imagine us losing this case, but if we do, it's a DUI conviction. And man, that's a couple sleepless nights, because you're making a huge decision here. Plus, you got to take the whole day off work. You might go to jail. So now we got that factored into it as well. It's a huge decision for people to make and a difficult decision. And I'm glad in this particular case, we stuck it out because the case was just dismissed today. It was null prost. And what that means is the state of Florida has decided to drop the case. So the judge didn't order it be dismissed. I didn't, well, we definitely worked some magic on the pretrial stuff, but based upon the evidence that we were able to get eliminated, the state attorney's office on their own just voluntarily dropped it. And client ecstatic, sorry, hypothetically he's ecstatic because he doesn't exist. And really big win, really big win. God bless, guys. I'll put a link to those other videos right here.